To the Hartley Law Group. I'm Albert Hartley. On this beautiful August day, it's incredible today, and I mean wearing my bright blue suit with the lavender. It's lots of colors, which is part of my whole new life thing that I've got to be working up. So we're starting a whole new life and a whole new trend. Today I want to talk about real estate. I know everybody's shocked by that, but I've been focusing on some parts of real estate that have been more specifically inclined to not negotiations, but cleaning up issues related to title defects lately. And I thought it might be interesting. Some of the title defects have to deal with the way people own real estate, different corporations and trusts. So I thought I'd do a quick video on making sure that the title to real estate is held in the right name. And so if sometimes a trust is just a vehicle, a legal structure to hold property. And many times people will put a piece of real estate in the name of a trust, but technically it should be in the name of the trustee of the trust who's holding it for the benefit of the beneficiaries in the trust. I know it sounds like a horrible lawyer thing, but that's the whole process. So if you've got a deed that says, hey, this is going into the so-and-so ABC trust, it actually should read, it's going to John Smith or Jane Smith, trustee of the ABC trust. That's the proper way to hold title to the real estate. And then within that trust document, you have different clauses or conditions related to the real estate, and those would then govern the beneficiary distributions as well as the trustee activity. So if you're going to do a trust, and I really like trusts for certain types of transactional issues dealing with elderly people, divorce. You've got issues with dealing with holding title with corporations that may have judgments against them and some other things. So you've got to be really careful to make sure the title to real estate is held properly. The other thing that's really important, if you're going to be in a business like an LLC or a corporation, you've got to keep those corporations in good standing with the State Corporation Commission. If you don't, it's defunct or it's purged or it's terminated, and the actual entity holding the real estate now doesn't exist. So you've got to either reinstate that entity, or you've got to do a director in dissolution or some other ways to get rid of the real estate out of the company, which doesn't exist anymore. And so that can hold up a real estate transaction. So, if you're a real estate professional, like a real estate agent or an investor, you really need to make sure you speak with a legal counsel about how to hold title to real estate. I don't really recommend that you talk to a general practice attorney who doesn't know anything about real estate, because they frankly might not really understand the nuances. And I know that sounds ridiculous, but sometimes not everybody knows how to hold title to real property. So anyway, I hope this helps. If you've got any questions about trust, feel free to email me at albert@hartleylawgroup.com, and I'm going to take my lavender tie and go to another appointment. So